Thank you, everyone. Please be seated. All right, we'll now hear the arguments in McKee versus Capri Casino. Mr. Powell.
May it please the court. Good morning to the justices. My name is Steve Powell. I'm an attorney from the law firm of Swisher & Court in Waterloo, Iowa. And with my co-counsel, Steve Enochian from Walnut Creek, California, we had the pleasure of representing Pauline McKee in this litigation. There are a myriad number of issues that we could talk about in the case, and I'm sure we will talk about those that are of interest to the justices. I'd like to indicate, however, very briefly that we know that this case involves our client, Mrs. McKee, who on a family reunion trip to Waterloo, went into a casino, the Isle of Capri Casino in Waterloo, and while gambling with her daughters, plugged into a slot machine called a Miss Kitty slot machine, and no sooner had she done it when bells and whistles went off, and she had been advised that she won a bonus award of in excess of $41 million. You can imagine that she got quite a bit of attention at the casino immediately when those bells and whistles went off. Ultimately the casino refused to pay her, and that's what brought us to the litigation and brings us here today. We're here today because the district court granted summary judgment on the claim which raised three theories: breach of contract, estoppel, and violation of the Consumer Fraud Act, which obviously was something new and without any precedent in Iowa, at least. And so that, as you know, the court granted summary judgment, and I want to take a few minutes of my time because I think it's important to compare and contrast what the district court did with respect to the summary judgment motion. As the court knows, there's also a motion to dismiss the appeal based on, I believe, a contention that we did not have a proper purpose or any right to have Judge Geer, the trial judge, look at material from depositions that we had taken after the hearing on the motion for summary judgment. As you know, Judge Geer exercised his discretion. He allowed and in fact solicited more information from counsel at the hearing on the 19042 motion, and which was provided to him by both sides, and he certainly felt that that was an appropriate exercise of discretion on his part. In the original motion for summary judgment, which was filed on October 15th of 2013, the judge went through the various theories, and I'd just like to read from page 2 of his ruling. And when we talked about the breach of contract theory, the judge ruled, defendants argue that the only contract at issue between McKee and the casino was that established by the rules of the slot machine, which I can tell the justices, the rules of the slot machine did not provide Mrs. McKee or any other patron with any information about bonus awards. She could have pushed every button on that machine and turned as many pages as she could, and she would have never found any information about that bonus award.
Looking at it from a different angle, was there any sign posted, or did she put in her coin into that machine thinking she might win $41 million? Is there any bonus sign you could win up to $41 million?
Justice Waterman, she had no idea what she could win. She was just playing the machine. She had no thinking about it one way or the other. I mean, you know, this is a 90-year-old woman who played the lottery all the time, which, as we all know, you know, has reached, I don't know, $750 million or something like that for a buck, a scratch ticket. I mean, she was playing the game for enjoyment, had no idea what it would pay. And the only information on that machine was that a malfunction would void all plays. Nothing in that machine about any maximum awards. You cannot win more than so many dollars.
The rules of the game were accessible to her, correct?
They were accessible to her, but they didn't say anything about this situation.
They provided different awards that you could win under different circumstances, but there was no indication that you could win a bonus. Is that fair?
Could or could not, or that there was a maximum on any award granted by the machine. There was no information on that. Lots of machines we found through discovery in the industry have signs that say any award in excess of the stated number is void. It's a maximum. And in fact, in this case, there was testimony from the manufacturer of the machine that when they had notified the Isle of Capri and all the other casinos that had this type of machine, long before Mrs. McKee walked in there, hey, if you're operating this Miss Kitty machine, there's an opportunity here to have an extraordinarily large award in excess of $40 million.
This is a question about the record. Could you explain to me what this concept of legacy bonus is? And was there any potential for a legacy bonus that the casino had at least intentionally activated at that point in time?
The record, Justice, is that the casino had a legacy type bonusing system as part of their software. They changed in January of 2011, I believe, to a different form of software and did not disable the legacy bonus system. The November before this changeover took place, a technical bulletin went out from Aristocrat and said to the casinos, and there's no dispute in the record, that the Isle of Capri got this technical bulletin, which said, from Aristocrat, we have found that in rare circumstances, that machine, if legacy bonusing is enabled, can award an amount in excess of $40 million.
When the casino was utilizing a legacy bonus, what was this legacy bonus and how did it work? And how would the casino award somebody a legacy bonus?
It's a software component whereby they can award bonuses for certain things. And quite honestly, Justice, that's above my pay grade on the technicality of it. It's a software component, and they changed their software to a different type of system that was called, I believe, an AFT.
I mean, I kind of looking at the record get the impression it's almost like something where the casino manager sitting in the back room could say, well, Ms. McKee's been playing that machine for 10 hours and she's down. I'm going to give her a bonus. It's not like that.
It's not like that. It's part of the software. It's computer. It's random. Okay? There's no thought behind, hey, here's somebody that'd be a nice candidate for a bonus. So the technical bulletin said, which they received in November of 2010, it said, hey, if you've got a Miss Kitty machine manufactured by Aristocrat, if you have a legacy bonus software, we're putting you on notice that there's a possibility of an extraordinarily large award in excess of $40 million. It had happened. That's why they sent out the notice. We've got...
Counsel, how does that fact help you, or under what theory does that fit in?
It helps us because the casino knew and did nothing about it.
But this is a breach of contract claim. At least your first claim is.
No question about it.
It's not fault-based. It's not a negligence claim.
No, so but unilateral mistake certainly would play a part in this contract case.
Well, it's a unilateral mistake if you can establish that there was a contract in the first place. Unilateral mistake under contract law, under certain circumstances, is a way to avoid a contract that already exists. But where's the contract?
Well,
that includes entitlement to a legacy bonus or any kind of bonus?
the contract claim, of course, arises under the standards set forth in Blackford versus Prairie Meadows. And for the first time, Iowa decided, what are we going to do here? We're going to follow Plan A or Plan B? Is our gaming in this state going to be one of those systems that's totally governed by legislative enactment? Or is it going to be on your common law contract theories? And this court cited the Ledoux case from Louisiana, which, as I'm sure you've read or heard, is so close factually, and I think legally, to what we're dealing with here, as to be, if not on all fours, it's on 3.5s. We adopted in Iowa, through the Blackford case, contract principle. And I'll just make this comment. The casino, in all of its briefing, relies on case law from jurisdictions that do not follow that principle. They have not adopted that approach to gaming laws. They have instead cited us to cases, primarily Pickle and Eesh from Mississippi, which is one of those states that is totally governed by legislative action. And their regulators are by statute directed to resolve any patron disputes. And of course, in Blackford, our court decided, no, we don't have that.
But under Blackford, you still have to show a contract. Where is the contract that entitles her to this $41 million bonus?
She placed her money in the machine. The casino, under Blackford and under numerous cases that follows contract theory, says it's typical common law contract. When she walked in there, they've got that machine, and the casino makes an offer. She accepts that offer when she puts her money in.
Flip the facts the other way around. Let's say the symbols lined up, and under the rules of the game, she would have been entitled to $10,000 or whatever. And the machine didn't display the award. She'd be entitled to that money, right?
Well, no, because I think the case law indicates that the fact that she's there at the time and it's contemporaneous that she has won at that point in time, her expectation is fulfilled.
But it's still, you still have to have a contract that a trade of promises, a promise that you will receive this $41 million if you go in and put your money into the machine. And it seems that the only promises that were made were those that were set forth in the rules of the game, right?
There were no promises set forth in the rule of games with respect to bonuses. None.
And
I mean,
doesn't that defeat your claim, or at least
I don't know
create
why
a
it
problem
would. The
for it?
nature of playing a slot machine is putting the money in and seeing how you do. I mean, it's not like anybody's going to say, well...
It's a little more complicated than that. It's putting your money in and seeing which pay line you come out on.
Granted, I mean, there's that technical.
And
it's not,
where was the pay line on this machine for $42 million?
no, because there's no pay line at all for a bonus. A bonus is separate. It's something that isn't affected by the configuration of the reels.
I'll give you another hypothetical. I go in and I play blackjack, and I'm just playing along, and the dealer, after a hand, blurts out and says, "Oh, bonus, $41 million, Mr. Mansfield." Do I have a claim to that $41 million based on what the dealer said to me?
I think you probably have a fact issue there that needs to be resolved.
Wasn't the bonus came into play after the coin was inserted?
After she, pushed the button, actually is what happens here. She pushes a button. And yes, the bonus was displayed after that happened.
So that was a new term to the contract that came into existence after the coin was put in?
It was part of the response of the machine.
No, but if we're talking about what are the terms of the contract, as Justice Wiggins said, there's certain things on the machine that explains how you win money.
The terms of the contract are, as I understand Blackford and the other case law that's been cited, is that if you put your money in or press the button on a credit card or however you're paying for it, if you do that, you've accepted their offer to get whatever the machine gives you. And if you're there and the machine says, here's what the machine's going to pay you, here's what you got, and there's no evidence of malfunction, because what they say on that machine in big letters on the front of it, Chief Justice, is malfunction voids all play. There's no evidence of malfunction here, and the casino is not relying on malfunction here, although I think Judge Geer did at the trial court level in his initial decision in October of 2013. And you have those, and I mean, I won't read them now, but he did talk about malfunction, and he talked about a letter from the Iowa Racing and Gaming Commission dated September 30th of 2011 that said, hey, we had GLI, which is the industry-kept forensic people who look at all the machines after an award. If an issue comes up, that's what happens. GLI said, well, we think it must have malfunctioned. But the record in this case, the record that was developed in this case, the jury would have heard evidence from the defendant's own witnesses. There was no way to identify any malfunction in this machine. And of course, we addressed the letter of September 30th in our briefing. It said, you know, Judge, you really can't rely on that because nobody is saying there's a malfunction except you in your original decision, which is why we went back and asked him to enlarge or amend based on these additional facts. We had the depositions from the people from the Iowa Racing and Gaming Commission. They never asserted this theory that somehow they could rely on their pay sheets or pay tables in the machine or the rules of the game to void this. They never relied on that theory.
Well, at the time the coin was deposited into the slot machine, what were the terms of the contract?
Terms of the contract were you put your money in, you get what the machine tells you you're entitled to.
And where did those terms come from?
Those terms come from the case law. It comes from Blackford.
So she was relying on case law?
Well, of course not. Anybody that plays a machine relies on the fact that when they put their money in, the machine's going to tell them what they get.
There was a play line here.
There were play lines here for the spin of the reel, but the industry doesn't use those pay lines.
Well, does the contract use those pay lines? Do the pay lines have any significance in this case?
Sure. There's two components to an award that machine could make, and everybody knew it. Everybody on the casino side. Mrs. McKee didn't know it.
But did the machine say that you can get a bonus of $42 million?
The machine didn't say anything about bonuses.
And the machine, so by its silence on bonuses, you're saying the bonus is part of the contract?
Well, here's where it wasn't silent. It wasn't silent when the machine went off and said, you just won a bonus.
But that's an after the fact. When she entered into this contract, and put that money in the machine, there was no expectation of a bonus by her, was there?
There was no expectation that she'd get anything. That goes with playing a slot machine.
Other than what the pay line said?
No, not other than the play line. She had no expectation of anything. There's no evidence in the record of that. She was going to play the machine and get whatever it gave her. But there's case law, justices, that say if she does that, she's entered into that contract, and if there's no indication contemporaneously at the time the machine shows what she's going to be entitled to, that there was a problem, a mistake, a malfunction, if there's no explanation on the machine that there's a maximum award that can be given, then their contract is formed at that point. That's the law as I understand it in the case law, and I think it's pretty clearly set forth, and I think we cited those cases in our brief. Now, what's happened here is the casino convinced the trial court that it was an illegal contract. And we've briefed that so thoroughly. Whatever happened to principles of contract construction? I mean, if Blackford's the law, how can we avoid applying those principles of contract construction without her having any opportunity? There are so many genuine issues of fact involved here from experts on both sides who agree, and I think it was of great interest when I asked the primary expert for the casino, would you agree with me that Mrs. McKee, as a patron of this machine, would have had no way of knowing from anything that was on the machine that the award was not valid? He said, well, I can't speak for Mrs. McKee, but it would not be obvious to a patron. But the manner in which it was depicted to the patron, did that make it obvious that she had won purportedly $41 million plus? It appeared obvious, yes. I mean, I'm not saying we win here. I'm saying we should have had an opportunity to present these issues to a jury on ambiguity, to resolve the facts. This jury, based on the record that was developed at the time of the summary judgment, would have heard evidence from experts on both sides that this was not a malfunction, that the manufacturer knew about this possibility, advised the casino of it, but apparently the casino, in simply failing to flip a switch inside that machine and disable legacy, which is what Aristocrat told them to do in the technical bulletin, or to post through new software that was available from Aristocrat a simple statement that said, any amount in excess of X dollars is void. They didn't do either one of those things. So when it happened, pretty embarrassing for everybody, including the IRGC, who had notified them, and nothing had been done. And now it's an illegal contract. You know, the ironic part about this is under contract principles in Iowa and the standard that we've adopted here, she would have had an opportunity to litigate these fact issues.
Thank you, Mr. Powell.
Thank you.
Mr. Schultheis.
May it please the court, counsel. My name is Mark Schultheis, and along with my co-counsel Stacy Cormican, I represent the Appellees in this action. Briefly, I'd just like to point out there are two named defendants in this case. IOC Blackhawk County, Inc., as the gaming license holder, is the only appropriate defendant. Isle of Capri Casinos, Inc. has no gaming license and is not a proper party to this case. The Iowa Racing and Gaming Commission must approve all the terms of any gambling contract in the state of Iowa. This includes any award that may be won. If the IRGC has not approved an award, there can be no contract between a casino and a patron that would allow the patron to win that award.
But didn't they approve bonus awards?
In this case,
In different slot machines, whether it's this one or anyone else?
there's no evidence of any bonus awards that were submitted to the IRGC by the Isle or approved by the
But are
Isle.
there any evidence that they disapproved a bonus award?
Under the regulations set forth by the IRGC, in order for a casino to award a bonus, it has to submit a request in writing to get that approved. For instance, a good example would be if a casino was interested in awarding some sort of system bonus to give away a car. They'd have to submit to the IRGC in writing the rules, the regulations, the payout odds to give away that car. if they don't receive that written approval from the IRGC, the casino can't give away that car.
I mean, I think Mr. Powell has a point. If you want to, there are two separate issues. There's sort of, is there a contractual entitlement to the bonus? And two, if there is a contractual entitlement, was the contract illegal under the IRGC regulations or laws? And do we even get to the legality question unless there's first a contractual entitlement?
In this case, Justice Mansfield, I don't think you get to that second question because the key here is what was the contract? And the contract is the offer made by the casino spelled out in the rules of the game. And that is simply that if you place your wager, you can win if the reels align in a certain way, and you will win according to the pay table, which determines, based on the alignment of the reels, what you win.
I asked Mr. Powell about this legacy bonus. I kind of want to ask you the same question. Is his explanation of it, do you agree with that? Is that basically correct? That it was just something that would kind of pop up on the machine every once in a while, and the patron would be told they got a bonus, and it was out of the control of the casino?
If a legacy bonus was a part of the game, it would be something not based on the alignment of the reels. That I would agree with. It would be something that could come up in more of a random manner. There was no legacy bonus as part of the rules in this game. There were no legacy bonuses submitted to the IRGC. Legacy bonusing is truly not a part of this case. I mean, the fact that it's brought up by the plaintiffs, I think, is just a red herring. And in fact, they don't even rely on the term legacy bonusing when they try to say there's a contract for this bonus award. They use the term system bonus, which is something a little bit different. And if you'd like to, I could explain exactly what that is, too. A system bonus is the slot machines in the casino are all linked to this central system, which monitors information that goes to and from each slot machine. This sort of centralized system can be set up to randomly award a bonus, which would be a system bonus. It can be set up that way. But the IRGC considers a system bonus to be a gambling game that requires approval, just like anything else. The actual IRGC regulations, Chapter 11.5, Sub 3 and 4, specifically require, if a casino wants to award a system bonus, they have to submit a request in writing to the IRGC for approval. But a system bonus was not set up on this machine. The casino didn't have system bonusing of any kind in this casino.
You're saying, and you seem to be saying this in your brief, is the casino didn't intentionally set up any kind of system bonus. What we have is a situation where they didn't follow the directive from the manufacturer to affirmatively disable the bonus feature in the machine, which would have been an additional precaution they could have taken, right?
The casino absolutely did not intentionally award any system bonus or any bonus of any kind on this slot machine. The second part of what you're asking, Justice, is a little bit, I think we've had a little bit of misstatement about what happened there. The machine itself had a setting to enable or disable legacy bonusing. And when the manufacturer of the machine was at the facility, it set up the parameters of the machine. Nobody at the casino did. It was the actual manufacturer. And the manufacturer, according to their own bulletins that came out, should have disabled the legacy bonusing switch, but he didn't. That's the issue with that legacy bonusing. If that is specifically what caused this machine to make this display, there's no real evidence in the record as to what actually caused the display. So getting back to Iowa law, I think, is pretty clear on this. This court in Blackford did address, you know, what sort of contract there is between a patron and a casino. And what this court held in Blackford was actually very narrow, because the Blackford case involved something very specific, and that was Mr. Blackford went out to Prairie Meadows. He had been involuntarily banned from the casino. He went out there anyway. He won a large sum of money, and Prairie Meadows figured out that he was banned, and they refused to pay him his winnings. So he sued, claiming that Prairie Meadows was liable to him under a conversion theory. So the very narrow issue decided by the court in Blackford was they were looking to see, does the IRGC have any regulations which apply here such that the casino could confiscate the winnings from a patron who had been involuntarily banned. There was a specific regulation that dealt with a voluntarily banned.
There was a contract claim in Blackford too, and what we said is there was no offer and acceptance, so there wasn't a valid contract because this guy was told he didn't have an offer to come to the casino and gamble.
And that is the holding in Blackford. What the court had to eventually do was looking at the conversion claim. The conversion claim required Mr. Blackford to show he had a possessory interest in the winnings. So that's how the court got to the contract issue. And the court said, what we do here is first we look to see if are there statutes or regulations that apply. Absent that, we go to common law ordinary contract principles. But the court went a little farther than that, because the court held that you also look at statutes and IRGC regulations as a part of any gambling contract in Iowa. And then the court said, well, there wasn't a regulation that applied, so we'll look at ordinary contract principles. The court looked at the principles, said there was no offer to Mr. Blackford because he couldn't be there. Prairie Meadows couldn't make an offer. He couldn't accept the offer, no contract. Thus, he has no possessory right in the winnings.
This case presents a Consumer Fraud Act theory. Why doesn't that get him to the jury?
The Consumer Fraud Act doesn't apply here for a couple of reasons, Justice Waterman. First of all, I believe the trial court was correct in ruling that Ms. McKee had no ascertainable loss of money or property here. That's one of the requirements to bring a Consumer Fraud Act claim. And in order to have an ascertainable loss of money or property, which first of all she had admitted in her deposition testimony, she hadn't lost any money or anything because of playing this game. And the claim was, well, she lost that bonus award. Well, in order to have a right in that, she has to have a contractual right to it in the first place. And the trial court got that right. She didn't have a contractual right to that alleged bonus amount, and so because of that, she had no loss of money or property. There's another, I think, important reason why the consumer fraud claim fails, and that is because Iowa's Consumer Fraud Act has something that makes it very distinct from any of the acts that were cited by the plaintiff in her briefing, and that is Section 714H.4, sub 1, sub G, that excludes conduct that is required or permitted by the orders or rules of or statute administered by a state governmental agency. Here we have the IRGC, which oversees everything that any casino does in the state of Iowa. Everything a casino does has to be authorized by the IRGC. But importantly also, the IRGC, in this case, told the casino whether or not it was a valid award. The IRGC told the casino it was not a valid award. Because of that, the casino didn't pay it. The casino couldn't pay it once the IRGC tells it it's not a valid award. And so under the statute, that's conduct that is required or permitted by a state governmental agency. And that's, I think, a very key distinction about the Consumer Fraud Act in the state of Iowa compared to similar or dissimilar acts in other states.
And is there an absence of any deceit that caused her to put the coin in or press the button? There was nothing that was said to mislead her into thinking she might win $41 million. Is that an additional reason the Consumer Fraud Act wouldn't be violated here?
I believe that's correct. one of the things that was completely absent here was any representation or communication by any casino employee to Ms. McKee before she played the game. Her testimony was quite clear that the casino made no representations to her. She didn't speak with any casino employees before she played the game. And in fact, the only reason she played the game was because her daughter asked her to sit down next to her and play the game with her. So there wasn't anything that was deceitful or fraudulent on the part of the casino as well.
Mr. Schultheis, was the system bonus mechanism disclosed in any way, or was it buried in the software of the machine?
I'm not quite sure what you're asking, Justice Cady. Are you talking about a system bonus as I was describing?
Right, the opportunity to receive a bonus. Was it disclosed in any way?
There was nothing that addressed, are you talking about in the rules of the game? In the rules of the game, there's nothing that talks about bonuses in any way because there were no bonuses available.
About the casino itself, I mean, a player club or somebody gets notice that there's bonuses in these machines? Was there any notice at all anywhere in the casino?
There was nothing dealing with system bonuses anywhere of which I'm aware, because the casino wasn't awarding system bonuses in any way.
So it's somewhere in the software of the machine that the manufacturer is supposed to turn it off, you said?
The system bonus is a little bit different from
And
what
the
that legacy bonus. The
Okay.
legacy bonusing switch is actually on the machine. A system bonus deals with the casino's computer system that connects and links all these slot machines. There was nothing on that system set up in any way to be able to award a system bonus. This casino wasn't awarding system bonuses of any kind on any machines or any games.
But what's the responsibility of the casino then to flip that switch? It sounds like it's a pretty easy fix if you're not going to have a legacy bonus, whether you describe a legacy bonus or not, because I think it's clear from the record there's nothing that says anything about a bonus or legacy bonus here. But when they set up the machine, why doesn't the casino then flip the switch? It sounds like it's a pretty easy fix, so they can protect themselves from potential liability like this.
The acts you're talking about, Justice, I think, with all due respect, aren't pertinent to the claim here because it's a breach of contract claim. And I think that was discussed earlier. What you're getting at would really apply toward some sort of negligence claim. And what we have here is a straight breach of contract claim. The record's not clear that when the aristocrat, not the aisle technician, but the aristocrat technician set up the parameters of the game, he didn't disable it. But the record's not clear if that's actually what resulted in this erroneous display. But I think the key point is this is a breach of contract claim, not a negligence claim.
I'm still trying to clarify this system and legacy stuff. If you're saying was not doing system bonuses, if they had disabled the legacy bonus switch, like Justice Zager refers to on the machine, based on this technical advisory that they got, then that would have prevented any notices of bonuses, including system bonuses, if the casino had intended to award them. Is that a fair summary?
We don't really know that, Justice.
Okay. But it's at least an issue of fact. If that's we can discuss whether it's a relevant issue of fact, but there's at least an issue of fact or a material issue of fact.
I would concede if that was material, it would be an issue of fact.
You may sum up.
Thank you. The trial court understood the regulatory framework that was involved here, and as the trial court stated, the gambling contract created by the IRGC approved rules of the game is the only gambling contract allowed between a casino and a patron, and that according to the terms of the only possible valid gambling contract between McKee and the casino, McKee was entitled to winnings of $1.85. The trial court got that absolutely correct. The trial court understood what the terms of the contract were, and we would ask that the trial court's ruling be affirmed in all respects. Thank you.
Thank you. Thank you, counsel. And Mr. Powell, rebuttal.
This goes to a lot of the questions that we had earlier. I just want to direct the court's attention when we talked about Mrs. McKee's expectation on this. If you go back to Blackford, I think the answer is there. And if I may, cite from Blackford, we determine whether an offer has been made objectively, not subjectively. The test for an offer is whether it induces a reasonable belief in the recipient that the recipient can, by accepting, bind the sender. In making an offer, the offerer is the master of his offer, just as the making of any offer at all can be avoided by appropriate language or other conduct. So the power of acceptance can be narrowly limited. The manifested intention of the offerer determines the person or persons in whom is created a power of acceptance. An offer may create a power of acceptance in a specified person, or in one or more of a specified group or class of persons, or in anyone or everyone who makes a specified promise. In this situation, Prairie Meadows is the offerer. It makes an offer to patrons that, if accepted by wagering an amount and the patron wins, it will pay off the contract. It is not a subjective test. It's an objective test.
And that language is consistent with the common law of contracts, and I agree with you that the common law is relevant here, but the issue here is not offer and acceptance. The issue is what were the terms of the contract.
Okay.
Casino says the terms are the rules of the game, and you say that the terms are whatever pops up on the machine.
I agree.
As I understand the difference between the two of you.
I agree that the rules of the game are part of the contract. We have a fact issue on what the rules of the game are. We have all kinds of evidence that there are no rules of the game that apply to this situation, either for or against. I mean, that's a fact issue.
What if some smart aleck computer programmer in building this machine put in a legacy bonus that was in the form of a penalty, so it popped up on the screen that you owe $10,000? Would that be a part of the contract?
I think the contract would still be in existence unless illegality, fraud could be proved, and that would make for a great indemnity claim against that smart aleck, I suppose, from the casino.
But you think that would form the contract?
No, because I think that's fraud.
No, but you have to have a contract for the fraud to vitiate the
I
the
totally
contract.
agree with that. And what I'm trying to emphasize, Chief Justice, is that the contract here is an objective act determined by the circumstances at the time. And it's not complicated. We're going to pay you something. No, but you don't know what it is, but we're going to pay you something if you wager on it. And if you win, we're going to pay off the wager. That's the contract.
But if we go that route, aren't we basically saying that you can have rules of the game that were never considered by the Iowa Racing and Gaming Commission, never approved? If the rules that were approved, here's the payout system, but you're saying by silence you can have a larger award.
Granted, and I agree with that, but it's a fact question. Let me tell you, the evidence in this case is the Iowa Racing and Gaming Commission said if this award is found in this litigation to be valid, we would expect them to pay it. They aren't relying on anything that's being urged in this court, like there's some statutory prohibition against this or the rules of the game don't provide it. They've never made that argument. They said, we think our GLI forensic people think it was a malfunction, although they can't prove it. And that's what they relied on. And nowhere in this record has the Iowa Racing and Gaming Commission taken the position that, hey, wait a minute, this is in excess of the pay tables, or this has anything to do with the pay tables, or that the rules of the game provide something differently. That hasn't happened in this case. In fact, the evidence is to the contrary. And we provided all that
I just
information.
have a quick little interjection here. To me, I guess I take a little exception. To me, this is kind of a uniquely legal question that the court did in fact decide about whether there is in fact a contract, and more specifically the terms and conditions of the contract. I don't think that's usually something that we normally leave to a jury to decide what the reasonable terms and conditions or expectations of the parties were to a contract. I know you obviously disagree, and if the chief will allow you to respond, that's fine.
I do disagree, Justice Zager, because the rules of the game do not address this situation, and where the court found in its ruling on the motion for summary judgment that there was a $10,000 maximum that was displayed in the rules of the game, that was simply a mistake. That's why we filed our 19042 motion. It was not accurate. It was not based on the record. May I make one more quick point, Chief? Thank you. On the Consumer Fraud Act, I just want to say that the only reason motion for summary judgment was granted on the Consumer Fraud Act was because the trial court found that she did not sustain any damages. That wager, we provided all kinds of case law on this, that wager and the payment of what the machine displayed vested in her at that time a property right in that. And we've cited cases that say from other decisions in other jurisdictions on consumer fraud acts that are similar to ours, that she did suffer damages by losing that property right.
But we can also affirm on alternative grounds urged below. So could you address the other two reasons that were your opposing counsel discussed why there's no, as a matter of law, no Consumer Fraud Act? The state agency oversight or the absence of deceit that caused her to push the button?
There is no state agency oversight in a patron casino dispute in Iowa. There is none. That's the problem. That's why Blackford and Ladue in Louisiana said it's a contract claim, and that's how it should be resolved. At no time did the IRGC assert anything other than our forensic guy says this is a malfunction. And there's all kinds of genuine issues of fact in the record about whether it's a malfunction. Thank you very much, Justices. We would respectfully request that the decision of the lower court be reversed and that the case be remanded for trial. Thank you.
Thank you as well, Mr. Powell, and to both counsel for arguments. The case of McKee versus Capri Casino is now submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.